in our state. He will describe how each case and the court's decision in that case establishes precedent for or raises questions about mediation procedures and practices in Texas. Dr. Roberts holds a JD from Southern Methodist University and a Doctorate of Education in Higher Education Leadership from Sam Houston State University. He has held numerous leadership positions in professional mediation organizations, including being past president of the Texas Association of Mediators, past chair of the Dallas Bar Foundation's ADR Section, past chair of the ADR Section of the State Bar of Texas, and current board member of the Dispute Resolution Center of Montgomery County. He speaks regularly on mediation-related topics, including ethics, legal updates, and related issues. Dr. Roberts is the 2023 Susanne C. Adams Award recipient from TAM, and he tells me that he welcomes your questions. He encourages you to ask him questions, that you do not have to wait till the end. You can put the questions in the chat, and I'll be monitoring the chat just in case Jean misses something. Um, He'd also like your permission to take a screenshot of the attendees to share on social media. If you would prefer to not be included in that shot, please turn off your camera or drop off for a moment now, and then come right back to the meeting so you can hear everything Jean has to say. You're going to be receiving an hour of uh, continuing mediation education, hour of CLE if that's what you've requested, and 0.25 of ethics. So, Jean, go take your picture.
Okay, thank you for that, Linda. Yeah, I like to take pictures because it helps my boss know that I'm actually working and doing things instead of just writing them down on a report. And so we're going to take a snip in just a second. So if everyone, smile if you want to. If you don't want to be in this, that's cool too. Just turn the camera off or turn your name off, whatever. All right, give me a second. Here we go. 3, 2, 1, smile. Okay. Dun, dun, dun. Great. Thank y'all very, very much. That'll go on LinkedIn and Twitter. And thank you very much for that. We did practice this to see if the screen would work. So let me do this, do that, and change display settings. All right, everyone see my screen okay? It should say mediation law update Texas style.
Yep.
Fantastic. Well, thank you all for having me. And pardon me, I'm getting over a flu, cold, whatever combination it is. And so I've got some hot tea, but if y'all give me some grace on that, please. Couple of things. I want to thank Linda and y'all for being here today. And thank you so much for having me. I also want to thank a couple of other people. One is Victoria McClendon Leggett in our office. She's an attorney, and she's helped out with some of the work on this. And then another person who's helped out a lot is a fellow by the name of Jack Leach, who I knew his father, and Jack is studying business at Indiana University, and we have sort of a mentor-mentee type relationship, and so he's helped locate some cases and helped out with this presentation together. As we get started and talking about some of these cases and decisions, and to make sure that we get the 0.25 ethics part of this, as we're talking about these decisions, I would like for us to have sort of a seed planted in the back of our minds about the ethical guidelines for mediators that's been passed by the Texas Supreme Court and amended, I think, just once over the years. And here are some of the guidelines I think may be implicated with some of the decisions today. I'm not going to do sort of a one-for-one, but one of them is Guideline 7 about convening the mediation. And our ethical guideline for that says that mediation should not be convened unless all of the parties and representatives ordered by the court have appeared and have adequate authority to negotiate, with adequate time being reserved by all the parties to allow the mediation process to be productive. And so in at least one of our cases today, there's not a question about convening, but how long should the mediation last and how long do people have to stay in it? Another guideline that we have in our ethical guidelines is guideline number 8, dealing with confidentiality. We have at least a couple of decisions that we're going to discuss today that talk about what is confidential, what can a court listen to in terms of testimony from and by whom. Another guideline is number 12 about no judicial action taken. In that guideline, it says that the mediator should not subsequently serve in a judicial or quasi-judicial capacity, such as an arbitrator, unless the mediation has come to an impasse and the parties have agreed that the mediator may serve as arbitrator. Guideline 13 talks about the termination of the mediation session, and that guideline states that the mediator should postpone, recess, or terminate the mediation if it is apparent that the case is inappropriate for mediation, or one or more of the parties are unwilling or unable to participate meaningfully in the mediation process. And then finally, as I was looking through these decisions, guideline 14, the mediator should encourage the parties to reduce settlement agreements in writing, to be in writing. I had asked artificial intelligence to do a background for this presentation to show Texas landscapes. And for some reason, AI initially thought all Texas was a bunch of cacti. And so we've got this. I said, well, we need to have some trees in there too. So this is a AI generated background for this. I've got to give y'all a couple of disclaimers. And so I asked AI, show us a couple of Texans. And of course, it's cowboys. But the first thing is that while I am an attorney, please do not consider this legal advice. It's education. It's summaries of decisions. I get things wrong. You may read these court cases and have a different opinion or conclusion than me, and that's okay. And, at least I just want to try and point you in the right direction. Pardon me. And then the second thing is that whatever I say today doesn't represent my employer, state of Texas, maybe not even me. And so I try to be funny with a sarcastic sense of humor, dry sense of humor. And so, we'll go from there. Another thing that's important to me is that I think the law should be accessible to folks. And so one way to get access to these decisions that we're going to talk about today is through Google Scholar. There are other online resources that you can get access to court cases, but Google Scholar actually has access to Texas courts. So you can just take your favorite browser and go to scholar.google.com, click on the Texas Court button, and you can insert the names or the citations for these cases, and they should show up. And I know that there are others. I'm not endorsing Google at all, but it's just one of several that's easy. So, pardon me, the first decision that we're going to talk about involves a pre-suit agreement to mediate. And this is a decision that came out of the Texas Supreme Court last year, and it's titled San Jacinto River Authority versus the City of Conroe. And one of the reasons I enjoy reading these court decisions is that I just learn so much about how things actually operate. And so this is a really nice decision if you're interested in how river authorities operate and what their relationship is to cities. River authorities essentially sell water to cities, and they have agreements for this. And this is one of those cases where I know we're recording, but I kind of got a chuckle out of the first paragraph of the court's opinion. And the Supreme Court starts off like this. The parties to water sales contracts are before the court for a second time. Unlike a typical contract dispute, all of the parties here are government entities with immunity from suit. So far, their taxpayers and ratepayers have been funding only procedural and jurisdictional skirmishes distantly related to merits of the dispute. So I thought that was an interesting opening paragraph. And so there's a contract between a couple of the cities, including the city of Conroe, which is just a little bit south of where I am. I'm in Huntsville, and the San Jacinto River Authority. And they had a contract where the river authority was to sell water and to the city, and the city was to agree to purchase it. And there's under the local government code some immunity provisions and waivers when governments are involved with contracting. And so maybe the details of this case aren't terribly important, but the contract between the San Jacinto River Authority and the city of Conroe actually had a mediation provision in it. And the mediation provision of that contract required that the parties engage in pre-suit mediation for performance defaults, but not payment defaults. And what had happened is there was a dispute, and the city of Conroe quit making payments to the San Jacinto River Authority. And so probably, as the Supreme Court noted in its first paragraph, some overly technical maybe, but important to the parties' stuff is when there's a pre-suit mediation provision and these types of contracts between governmental authorities and immunity waivers are involved. In this case, the San Jacinto River Authority did not submit the dispute to pre-suit mediation. It filed the lawsuit. And the question is really, what does that do with respect to governmental immunity? And under the local government code, does that require that the lawsuit be abated until mediation can occur to comply with the contract? Or does it require dismissal of the lawsuit for failure of a condition precedent, essentially? And what the Texas Supreme Court here held is that the parties agreed to mediate certain claims, but it was a contractual prerequisite, not a statutory prerequisite. And so even though the lawsuit was filed, a court could abate the lawsuit in this type of circumstance, order the parties to mediation rather than dismiss the suit. And the court also held that contractual procedures for alternative dispute resolution, which can be enforced against local governments, don't serve as limits of the waiver of liability. They are made enforceable against the local governments, but don't serve to limit waiver of immunity on the local governments. We're going to talk about some cases now involving the mediator. And so the first one we're going to talk about is Daniel versus Morris. This is out of the Houston First District Court of Appeals. This is a divorce proceeding. Daniel, husband, Morris, wife, were involved in litigation after their divorce, where he sued her for defamation, and then she filed a suit to modify the custody arrangement about their child. These two different lawsuits were mediated and resolved in a single settlement agreement, or so it seemed. Daniel afterwards sued Morris, the mediator, and the mediator's law firm, alleging that they all violated the confidentiality provisions of the mediated settlement agreement. What happened, is that the parties agreed that things would be confidential, and there was another action going on in another state with one of their new wives as a party, and they wanted to make sure that the new wife and her attorney in the other state didn't really know anything about this action in Texas. And so what happened is that the mediator signed the mediated settlement agreement along with Daniel and Morris, and the signature block that the mediator signed was under the same one that the parties had, which stated approved and agreed to the terms of the settlement agreement. Their attorneys also, the parties' attorneys also signed the settlement agreement, but in a different section that said approved as to form. And so the breaches of the confidentiality included that the mediator filed an unsealed and unredacted copy of the settlement agreement with the court via e-file. Then there was an unsealed and unredacted proposed order that was filed. There was an unredacted motion seeking entry and those types of things. Mediator filed a no evidence summary judgment motion saying, I'm not a party to this agreement. I get nothing out of this agreement. I have no interest in the children. I was just the mediator, and so I cannot be sued under the agreement for violating the confidentiality provision. And what the court held is that when we look at a mediated settlement agreement and related documents, we've got to read the settlement agreement in harmony with its other terms. And so while there were confidentiality provisions in this mediated settlement agreement, there were also provisions that would say either party could enforce this agreement, if the other party breached it, which I think is maybe typical type of language. And the court held here that, I had to answer the question, is the mediator a party to the mediated settlement agreement when the mediator signed it? And the court said, under these circumstances, no. And the reason is that underneath the mediator's signature, it had the title mediator, so it wasn't party or, attorney. And the fact that the attorneys signed one that said approved as to form only, and the mediator signed underneath the parties, the court found really wasn't important. The court also found that there were a number of facts that would establish the mediator was not a party or otherwise contractually bound by this mediated settlement agreement. There was a defamation suit that was resolved. Mediator wasn't party to that. There were, custody. That mediator had no interest in children. A number of other things. The confidentiality did not mention that the mediator must keep this confidential specifically. It said the mediated settlement agreement said that if there were disputes, they would go to a mediator first before going to court. And the mediator who helped these parties with this dispute was listed as one of 5 mediators to be considered for the next mediation if there was a dispute. There's also an arbitration provision where the mediator in this dispute could act as arbitrator if there were questions about drafting disputes. And if you're going to be an arbitrator, then you can't be a party to the suit. And so the court rejected, in this case, Daniel's position that the signature on the mediated settlement agreement by itself makes the mediator the party. But the court gives us this counsel too. Says the mediator's signature standing alone is admittedly less clear than it could have been as to his status as a signatory, but the lack of clarity does not make the agreement as a whole ambiguous as to whether he's a party. The mediator signed the agreement in his role as mediator, and mediators are customarily not parties to the agreements that they broker. And so one of the things I'm taking away from this case is, for those of us who do sign the agreements as mediator, make sure your title is mediator. I don't know that you have to say mediator and not a party to the settlement agreement, but maybe language like that would be helpful to provide another level of defense if someone says, mediator, you did something wrong by e-filing the mediated settlement agreement, which had confidentiality provisions. And so again, I'm not taking a position about whether the mediator should e-file or file with the court the mediated settlement agreement. I know that happens customarily all the time. But I, perhaps just think about what are we doing when we're signing stuff, and is our role clear, and is there language in the settlement agreement, the mediated settlement agreement, that A, we're not a party to this document, and B, if someone sues us, the person that sues us has to pay for our time and defense costs and things like that. So those are some things to think about. This next one is a business dispute, LNS Proline versus Gagliano. This comes to us from Beaumont. The L&S company was owned by two people. One had a 75% share, one had a 25% share, and there was a dispute over things. Supposedly, Gagliano refused to do his role as chief financial officer. There was deterioration in the relationship. And so the other shareholder of the company, so to speak, wanted to buy out Gagliano. And so the company agreement for the L&S Pro line actually had language in it that said, before you go to court, we're supposed to mediate any business disputes. And so there was also a provision, and the law calls it a push-pull agreement or push-pull provision in a contract where someone is able to buy the other person out, essentially. And so the large owner wanted to do the push-pull against Gagliano, the smaller owner. And Gagliano was saying, look, before you can get me out of here, there has to be a mediation. And under our company agreement, it said not only do we have to mediate the dispute, but we have to continue to mediate until the controversy is either resolved or the mediator makes a good faith finding that no possibility existed that the case could be settled through mediation. And in this case, neither one of those things occurred, according to the appellee. There was a mediation that resulted in an impasse. There was a second mediation that also resulted in an impasse. That mediator offered a mediator's proposal, which was not mutually accepted. And so part of the question here is, what does it mean when the contract requires the mediator to make some sort of finding? Again, I'm so sorry for my cough. That the case could not be settled through mediation. And so what the court determined here, after looking at the company agreement, is said, the language in the company agreement says what it says. The mediation process shall continue until it's resolved, the controversy resolved, or the mediator finds there's no possibility of settlement, or the disputant, any disputant chooses not to go any further. And so one of the parties was like, hey, we need something from the mediator, says there's no hope of settlement. And that just didn't occur. And then there was a question about, well, does that need to be in writing or is something verbal okay? And what the court said is, we actually don't even need to get to that point. Here we had two mediations, after which no one wanted another mediation. No one agreed to the second mediator's proposal. And because no one was wanting to try to resolve this any further, then the requirement and the company agreement was satisfied. And so that rendered the fact that these parties did not continue to act in a manner to resolve the dispute through mediation showed that what they were trying to get with the mediator was actually a moot point. Next is a case called Batten versus Batten, and this is from the Beaumont Court of Appeals. This is a post-divorce enforcement action. And there's a court order requiring the husband to vacate the property. That was the marital estate, and ordering a receiver to come in, sell the property, split the assets, that type of thing. There was the agreed final decree of divorce was in 2019. And then there's a mediated settlement agreement that led to that agreed order. And part of it said, the house would be sold by date no earlier than the date certain, and for the best price, net proceeds to be split. 2019. 2021, the trial court signed an order referring parties to mediation to resolve a drafting dispute between the proposed order on enforcement and relief. And so the parties attended the mediation, and according to the court's opinion, the parties returned to mediation, and the mediator drafted an arbitration decision and award addressing the issue of the amount of the net proceeds and how much each party should get. The court also stated that the parties provided testimony and the mediator determined, one person would get this much and the other person would get that much. And so then there were, motions to sign and enforce the order. And the other spouse filed a motion to vacate the arbitrator's award, saying that there were some disputes about some expenses, and specifically that the mediator started a mediation but attempted to conclude it as an arbitration hearing and then presented a non-binding arbitration decision and award, and that was outside the scope of the mediator's authority. And so some stuff happened, procedural. Trial court ended up entering an order, and the appellate court said, if there's a mediated settlement agreement, it's binding when it meets the 3 criteria under the statute. It says that it's not subject to revocation, it's signed by each party, and it's signed by their attorneys. And that a court can't change or amend that for the most part. And what I think is important here in this case, and what is actually not discussed very much in the decision, is this transformation of the mediation that started as mediation, then went to an arbitration. And there are other Texas cases that say if the mediator is going to go into arbitration mode, there's got to be a contract, an agreement between the parties for the arbitration. And so this goes back to the ethical guideline about quasi-judicial actions that we take. It is not clear from this case, the decision reported by the court, if the parties agreed to the transformation of the mediator to an arbitrator, but the ethical guideline would certainly suggest that if we're going to mediate a case, we need to be mediator, and then we declare impasse, and then there's an agreement between the parties that we then act as arbitrator. And then there's even a question about why, in my mind at least, about why the arbitrator issued a non-binding arbitration decision. I'm not quite clear about that. But the court didn't get to that point. But to me, this shows, as mediators, we need to be careful about what we're doing and why and what role we're in. All right, let's talk about some mediated settlement agreements. This one is In re Montgomery out of the Eastland Court of Appeals. This is another divorce action, and what happened is there was a signed final decree that they wanted to present to the judge, but then one of the spouses wanted to revoke her signature because there's an issue regarding a property that had arisen. So the parties then agreed to attend a mediation. The spouses and their attorneys and the mediator all signed and agreed to be bound by an irrevocable mediated settlement agreement. The settlement agreement said that each party freely and voluntarily entered into the executed MSA. It also stated that there was no duress or undue influence exerted by the mediator, the attorneys, or any party. And it said if any party wanted to dispute the MSA, they needed to schedule a teleconference with the mediator first to discuss their concerns and for the mediator to interpret the MSA's terms before they went to court. And so in this case, the husband said, you need to grant the divorce decree based upon the mediated settlement agreement. And the husband also testified the mediation was great because the mediator provides snacks, water, restrooms. He could leave the party could leave anytime. And that his wife who wanted to withdraw from the agreement and the agreed divorce decree was saying she was under duress during the mediation. And so the husband testified, I had snacks, water, bathroom, I could leave at any time. And I never heard her have any sort of, loud noises or anything like that that would be suggestive of duress. The wife testified that she did sign the MSA, but she signed it under under 3 types of duress: economic duress, physical duress, and psychological duress. And when she was testifying about her duress to the court reported that she and her attorney were combative at times during the testimony. And then she also openly complained about the quality of his representation and questioned that during the testimony. With respect to the economic duress, she said, I was under economic duress because my husband took my retirement money, placed it into an account that I didn't have access to, and so I couldn't fight him during the divorce proceedings. For physical duress, she said, my husband was on probation for running drugs, and I know what he's capable of doing. And then also that she sleeps with a 35 and that she can take care of herself. She presented no evidence about psychological duress. And then she and her attorney after this started arguing with each other in the courtroom. And then the judge said, enough. I don't want to hear anymore. I'm going to set this for a final hearing. But the court here, the Eastland Court of Appeals, says, look, if the mediated settlement agreement meets the three requirements, under the party entitled to it's irrevocable, signed by the parties, signed by their attorneys, the trial court has no authority to modify that or to order the parties to modify or to enter a decree that modifies the MSA. The court did recognize that one can challenge the mediated settlement agreement through contract offenses like illegality, fraud, duress, and coercion. In this case, the judge stopped the testimony too early. I suspect it was because the party and their attorney were arguing with each other, and it essentially sent it back down to the court. But what the court here did say is that if you're going to present a duress challenge to the mediated settlement agreement, that the trial court has to allow the party to develop that defense, and then it must resolve any ambiguities in the mediated settlement agreement. And so in this case, despite the party and their attorney arguing with each other in court, the judge should have, according to this Court of Appeals, allowed that testimony to continue to establish whether or not she was under duress at mediation, and then determine whether the mediated settlement agreement was enforceable upon her. Our next case is In re Torres from the Dallas Court of Appeals. Again, this is another property division divorce proceeding. The parties, husband and wife, signed a mediated settlement agreement, and then the wife then asked the husband to change it. And she said, I forgot that part of the money that was in a bank account was actually an inheritance from one of my family members, and it should have been categorized as separate property instead of community property. And so would you please, let's change the mediated settlement agreement to reflect that proper categorization. The husband said, nope, we've got a signed mediated settlement agreement. It is what it is. And the trial court entered an order in favor of the wife because she had filed a motion to correct and reform the MSA, and then said, you guys go back to mediation to correct and reform the mediated settlement agreement. And then the husband filed what we have before us now, a writ of mandamus, which is to order the trial court judge to take an action. And so wife says, look, court still had jurisdiction over the case. When a court has jurisdiction over a case and the parties, they can refer people to mediation. That's all this judge did. And she said that the mediated settlement agreement should be set aside on the basis of either a mutual mistake or a unilateral mistake. And of course, the husband says, no, it was a mediated settlement agreement. We signed it and it should stand. The Court of Appeals of Dallas, citing some Texas Supreme Court cases, said that the trial court's not permitted to determine, in this case, if the mediated settlement agreement had a property division that was just and right, or generally complied with the laws regarding the division of marital property. And in this case, the trial court abused its discretion by evaluating the merits of the property division that had already been agreed upon by the parties. They also say that mutual or unilateral mistake has not been recognized by the Texas Supreme Court as a ground to avoid a mediated settlement agreement. And then they go into an analysis of mutual mistake and unilateral mistake. And what they said here is that this settlement agreement had a lot of language in it that shows that A, there could not have been mutual or unilateral mistake, and B, even if there was, the MSA had language to say, our property evaluations may not be right, but we're willing to go into this MSA anyway. So, for example, the MSA had language that said the parties had an opportunity to obtain a substantially full and accurate disclosure from all the other parties about all their other assets and liabilities, whether community or separate, and that they've been advised by their attorneys that additional discovery might be necessary to have a complete picture of the estates of both parties, and that they're satisfied with the disclosures that have been made, that they've reviewed the agreement with the help of their counsel before signing it, that they've reviewed the document carefully before signing it, and that it's binding on the parties, irrevocable, the magic language. And so what the Dallas Court of Appeals said is, given all of this, and it could be that there was a mischaracterization of separate property as community, but the parties bargained for that in their mediated settlement agreement. And because the settlement agreement met the statutory requirements to be enforced, the trial court had no discretion but to enforce the settlement agreement as signed, and that it erred when it sent the parties back to mediation, and when it said we're going to revise this mediated settlement agreement. Similar, Tamez versus Tamez from the Houston Court of Appeals, 14th District. This is a case where dad was in Ellis County, mom was in Galveston County. Divorce was filed in Galveston County. There was a mediated settlement agreement. Mediated settlement agreement said there's going to be a standard possession order, and also had this language in it. So long as the father lives in the current county, Ellis, and the children reside in Galveston or a contiguous county, then exchanges will occur at the McDonald's restaurant at the intersection of Interstate 45 and Highway 190 in Huntsville, Texas. And so long as the parties are exchanging the children in Huntsville, pickup time for the dad is 8 p.m. and drop-off time for dad is 5 p.m. So that was the drop-off, pickup time, and location. Then there was a hearing to enter a judgment based upon the MSA. Mom tells the court, my interpretation of the MSA is that I only have to drop off the children in Huntsville once a month, not every exchange of the children. Dad says, nope, we agreed to what we agreed, and all drop-offs and pickups are in Huntsville. And so the trial court said, well, it seems like there was a failure of the meeting of the minds with respect to where to drop off and how often. And so then the trial court ruled that mom had to meet father in Huntsville one time a month instead of the first, third, and fifth weekends. And then for these other weekends, dad is alone responsible for transportation. Dad said that the court erred by entering a final order that limited the number of times the parties would exchange their children in Huntsville because it varies from the mediated settlement agreement. Houston Court of Appeals noted, and I always like it when courts, look to the policy statements that are in our statutes. Here it said is the policy of the state of Texas to have peaceful resolution of disputes. That's why we have mediations, and a trial court has no choice but to enter judgment upon a properly executed settlement agreement, mediated settlement agreement, and that the court is not allowed an inquiry in that instance about what is in the child's best interest. Here, the court, the mediated settlement agreement met the three requisites. You know, it's irrevocable and bold or conspicuous writing, signed by both parties and signed by the parties' attorneys, if any. And so the trial court could not go back and say, well, we just get to meet one time in Huntsville for drop off and pick up the kid instead of three times. And so the Court of Appeals here said dad was entitled to judgment on the mediated settlement agreement as it was written, and that the trial court here, by issuing the decree, impermissibly altered the terms of the mediated settlement agreement. And we just see year after year after year cases where courts of appeals or the Texas Supreme Court will say, if there's a properly executed settlement agreement that meets the three requisites for family cases at least, you know, trial courts have to enforce judgment on those. They're not allowed to deviate from them. In the interest of IC, this is a SAPSR proceeding that went up to the Eastland Court of Appeals, and the trial court gave grandmother and both parents temporary joint managing conservatorship. Dad could have no possession of the children, and mom had to have a therapeutic program in order to have supervised possession and access to the children. There was a mediation that resulted in a mediated settlement agreement. It was signed by the parties and their attorneys. For whatever reason, the trial court did not sign an order that memorialized the terms of the MSA, which was in 2021, November 2021. There was no order until April 2023. And so one of the parents said, there's been some stuff that has happened in the last 17 months or so, and the court should enter a different order because of changed circumstances that occurred after the execution of the mediated settlement agreement. The decision does not talk about what those changed material circumstances were. But Dad says the court failed to consider them, and that there are fundamental rights of parents, and before a court enters an order, it needs to consider all the circumstances. The Eastland Court of Appeals here said, well, the MSA that was signed was complied with a statute, and the parties are entitled to judgment based upon that MSA. And if the court went into what's in the best interest of the children inquiry, that's not permissible under the In re Lee case from the Texas Supreme Court several years ago. It also noted that Section 153.0071 does not contain a provision that allows a trial court to reject an MSA based upon changed circumstances or the fundamental nature of parental rights. All right, we'll talk about some stuff that occurs in the mediation. First case is from Dallas, interest of GLW. This is another family divorce matter, and litigation in this divorce lasted for 4 years. The parties participated in mediation. They did not reach a settlement agreement, but the mediator and the court appointed amicus attorney, and the parties' attorneys still continued settlement talks. The night before trial, the attorneys reached a settlement agreement and presented it to the court. The parties signed it, and then after they signed it, the wife's attorney said, oh my goodness, this mediated settlement agreement left out details regarding child possession during spring break. And so we need to revise the MSA. And the mediator, for some reason, they asked the mediator to revise the MSA, and the mediator never did. And so that MSA was filed with court with spring break possession omitted. Then the parties participated in an arbitration before this mediator to resolve disagreements about property division, and the mediator / arbitrator issued an arbitration decision. Husband then revoked his consent to the arbitration, and then sent out his version of proposed decree. And the husband filed a motion to enter a final decree based upon the partial MSA that everyone signed, but didn't talk about spring break. Then the wife filed a motion revoking consent to that agreement. Trial court held a hearing and signed the husband's proposed order. What the court found here, the Dallas court found, was that, and there was a question about what did the parties intend when they were signing this mediated settlement agreement. And what's important for us for mediators, I think, and this is good, is that the court said, look, the mediated settlement agreement is a result of a confidential negotiation, and we cannot get into what the parties intended when they were agreeing to the terms of the mediation, because that occurred during a mediation, and that is all cloaked in the secrecy of the mediation process. They cite several court opinions in here that talk about mediation as a valuable dispute resolution tool, and that parties have to have confidence that their interactions and communications will be confidential. And if the court were to go into what were the parties thinking when they were signing the MSA to determine, did we forget something, or was a promise incidental, or was it a main promise, that gets into testimony that is not allowed to be examined by the court because of the confidentiality provisions afforded to mediations. There are some exceptions for that secrecy to be breached. Things like, well, I could have found out about it independent of the mediation, or there's a fiduciary relationship that was allegedly breached during the mediation. The new and independent tort is what that's called. But in this case, there were no exception that would warrant the disclosure of confidential mediation communications, and especially considering the private and intimate nature of divorce and child custody proceedings. So that was a nice case for mediation confidentiality. This one is Compost versus the Query Law Firm. Facts of this case are interesting. I would encourage you to read it. Essentially, the law firm had sued a number of its clients, or maybe former clients, for failure to pay for services, about $42,000 worth. At some point, the parties were ordered to go to mediation, and they did. And the Query Law Firm, after mediation, filed a motion for sanctions against the defendants because they had, quote, attended mediation in bad faith, end quote. The law firm stated that one of the principals of one of the defendant organizations left the mediation early and refused to be present during the entire mediation process. The court asked for sanctions, which the court denied. And I'm not going to get into the other details of the case, which really don't deal with mediation, but it's always interesting to me when people say someone didn't participate in good faith. And my understanding of the law and statute is that a court can order people, participants, organizations to attend a mediation, but they cannot order people to actually mediate or negotiate. And so, this notion of mediation in good faith, I'm not quite sure where that comes from sometimes, or to negotiate in good faith. But that was the allegation that was made as a sanctions motion by the law firm, and it was ultimately denied. But the other part of this case that I bring to your attention has to do with the ethical guideline, not about starting the mediation, because our ethical guidelines say we've got to make sure that when we start the mediation, there's adequate time for it, and that people are present who have the authority to negotiate. But how long does someone have to stay in a mediation? And this decision doesn't say how long the person stayed before they left. But again, it's just some stuff for us to, think about, keep in the back of our mind. In re Estate of Morgan from Dallas Court of Appeals. This case involved the appointment of a guardian ad litem and an attorney ad litem as part of a wrongful death and survival claims. It was a pretty terrible car wreck, to put it mildly, and the court appointed guardian ad litems for the three minor heirs. as well as an attorney ad litem for the decedent mother's unknown heirs. And so there were 4 mediations in this case. And the last one had some opposition by some of the parties, but, quote, because of an exchange between the mediator and one of the plaintiffs. Wouldn't you like to know what that exchange was like? But there was a settlement reached after the 4th mediation. None of the next of friends attended, nor their attorneys, but the guardian ad litem signed off on the mediation agreement on behalf of the 3 children. Court approved the settlement, and then there was an appeal. And essentially, the basis of the appeal was that a guardian ad litem does not have the authority to sign off on behalf of, in this case, the children. And so the Dallas Court of Appeals examined Rule 173 and what a guardian ad litem is allowed to do and not to do. And the court concluded that a guardian ad litem can attend a mediation, but unless there is a court order expanding the guardian ad litem's role, function, and authority, the guardian ad litem cannot sign on behalf of the children. What the guardian ad litem is supposed to do is attend the mediation and then report back to the court that there was a mediation, that there was a settlement agreement, and can report to the court whether or not it's in the party's best interest to approve it. But it's ultimately up to the court to approve that on behalf of in this case, the children. Here, the orders appointing the guardian ad litem did not expand the guardian ad litem's authority or explicitly say you may sign off on a mediated settlement agreement that's binding. And so from our perspective as mediators, if you mediate where there's a guardian ad litem, and you may do this, it may be helpful to look at the order appointing the guardian ad litem to see what authority the guardian actually has under the court order. And maybe have a discussion with the guardian ad litem about signatory authority and binding authority for others, depending on what the order says. All right, I know y'all are happy. This is going to be our last decision. Are y'all happy? Okay, I see one person smiling. All right, good. Okay, Mitchell versus State Farm Lloyds. This is one of those cases that you both love and hate to read. This involved Hurricane Ike and a homeowner who sued her insurance company and the roofing company and some other folks, and for damages. As part of the pretrial position for Hurricane Ike litigation, there was a standing pretrial order that required the parties to attend a mediation. And so in this case, there was a half-day mediation that happened in 2011. And then at the conclusion, the mediator circulated the document. It only had 4 points. And I say only, not judgmental, but it's very short. And it said, the plaintiff and defendants agree to settle as follows. 1, plaintiff will accept $34,000 in satisfaction of all claims. 2, the defendants agree to pay, the money. 3, the plaintiff will sign a release prepared by the attorney for each defendant, releasing all claims. And 4, all costs to be borne by the party incurring same. Everyone signed off on it. 5 days later, Mitchell, who was represented by an attorney and 5 days later no longer is, filed in the trial court something called a verified motion to withdraw consent to void the false settlement or to delay consideration of the false settlement until plaintiff has had reasonable opportunity to hire new counsel. That's the title. What she alleged is that her attorney encouraged the mediator to, quote, aggressively berate, end quote, her during the mediation, which aggravated her, quote, melancholic depression and caused her to experience suicidal ideation. She also stated that she did not have capacity to bind herself to the mediated settlement agreement and that her signature was obtained as a result of violations of the Americans with Disability Act. So she files that, and then the next day her attorney filed a motion to withdraw, which was granted. Not shocking. Then the defendants filed a counterclaim against her saying, hey, we had a mediated settlement agreement and now you're breaching it. We want to pay you money. So they made a counterclaim against her. Summary judgment was entered in favor of the defendants to enforce the terms of the settlement agreement. And so at trial court and on appeal, Ms. Mitchell said that the MSA should not be enforced because, I'm going to read part of the bullet points to you. She was diagnosed as depressed at the time of the mediation, and she had been prescribed medication. She'd been hospitalized for suicide attempts. She says that she informed her attorney and mediator of those issues. She also said that the mediator, quote, acted cruelly, yelling at her, belittling her, mocking her, and laughing at her, end quote. Also stated that the mediator, quote, continually expressed anger at her for wasting his and everyone else's time, and said that, quote, if she didn't settle immediately, her attorney would withdraw and her case would be worth zero. She also said that because of the mediator's so-called abuse, she experienced feelings of disassociation and suicidal ideation. She cried continuously for more than 2 hours, hyperventilated, pardon me, and sobbed, grasping for breath. She also stated that her attorney thought that her reaction to all of these things was funny, and that her attorney and the mediator laughed so much so at her that he had tears coming down her face, and felt finally that the mediator pressured her by saying that her case would be worth nothing and that no attorney would take her case once her attorney resigned. That's why she didn't have the mental capacity, she said, to actually sign, to properly sign the mediated settlement agreement. Court of Appeals in Houston said, look, everything you're talking about occurred during the mediation. Our statute says that what occurs in the mediation is confidential and a court cannot go into that. And so because of that, we can't hear any of that type of evidence. And there was no evidence that either the parties agreed to waive all their confidentiality in the mediation process, and there was no legal authority that she presented, none, that would say, hey, a court is allowed to look into these allegations despite confidentiality provisions for mediations. And so the trial court properly did not hear those types of allegations. Interestingly, she did make some other attacks to the mediated settlement agreement besides what kind of occurred in the mediation. And the one that was successful is that she said the mediated settlement agreement said that that the parties would release each other, but the documents that were provided to me by the insurance company and others had both release and indemnification provisions. And the court said here that the court agrees with Ms. Mitchell that the indemnity provisions are outside the scope of the parties' mediated settlement agreement. And it did not contain any language about indemnification. And so that indemnification provision is outside the scope of the settlement agreement and should not be enforced. So, my goodness, we are at 12:59. So I'm going to stop sharing. I'm open to questions, comments, thoughts, reactions, applause. Thank you for Friday, anything like that. And in all seriousness, thank y'all for being here and spending your Friday with us.
Thank you so much, Gene.
Yes, I think you definitely get applause, Gene, for trying to get all of those cases into that hour. You did a great job. And I appreciate seeing the citation for the case and your little snippet below, because sometimes I just can't get that all down, and I do appreciate it.
Well, and Linda, if you want, we haven't talked about this, but if you want, I'll be happy to put the slide into PDF format and send it to you. And if you want to send it to the group, that'd be fine with me.
That'd be wonderful. Yes, please do that.
Will do.
Okay. You're getting some real positive reaction there, Gene.
Oh, thank y'all so much.
We do appreciate your time and energy. I know this wasn't an easy thing to do, and it's great.
Thank you everyone for coming. If you need to go, it's 1 o'clock. Go ahead, and we'll see you at the next meeting or social.
Taylor?
Yes.
Thank you.
Yeah, one quick
Yeah.
question. Gene, this is Clay Avery. We're gonna, a lot of us are in the middle of a 40-hour training that some of us are teaching, and others, we have brought some of the students here. So we're gonna have to jump off. I did want to ask one question. Do you foresee Mitchell being appealed to the Supreme Court? Because I'm wondering, at one point, does mediator conduct fail to be covered by